Now, in this case, when A dies, shares go to heirs, the same way. Shares go to heirs. When A dies, in a tick, when A dies, shares go to heirs. That means if B dies, the shares go to heirs. Again, I need you to know the difference between this one and the next one. Next page. It also says right here, if a tenant in common wants to dissolve the ownership, but the other parties do not voluntarily agree to its termination, he or she may file a suit. It's not following me? It's false. Thank you. All right. So if a tenant in common wants to dissolve co-ownership and the other parties do not voluntarily agree to its termination, he or she may file a suit in court to partition the property. Partition is a separation. Okay? So if possible, the land itself may be divided into separate parcels, and that is called a physical partition. If there's no way to physically separate the property, then the court will demand that the property be sold. And that is called a judicial partition in green. Judicial partition.
You might not apart.
Yeah, if they agree to it. Yeah. If not, then the sale will be forced. It's like a divorce. We could easily just say, hey, just buy me out. But it doesn't happen that way. There's a fight most of the times. Now, something to remember. In New Jersey, a conveyance to two or more persons, please underline, two or more persons not married, circle, not married to each other, creates a tenancy in common, unless otherwise stated in the deed. So what we're saying here is very simple. A, let me go here. A put $30,000 and B put $10,000. I know it's weird, right? I have more shares than A, but I'll explain that later. If the deed does not explain that A put 30 for 1/3 and that B put 10 for 2/3, then how do we own this property? 50-50. So that's what we just read. It says right here, the tenant's shares will be equal unless otherwise described. Okay? So automatically, two people not married to each other creates a tick, and automatically, if nothing else described, our shares are equal, 50-50. Doesn't matter if I put $1 and you put $100,000, it's 50-50. Remember, the deed is like a partnership agreement. It should state your interest. And that's where a lot of people fail to observe. Well, I put 100,000, you put 1. Where's your percentage here? Nobody sees that. They just assume, okay, two people on the deed is perfectly fine. The deed is your partnership agreement, if you don't have one. You got it? The deed describes everything that you need. Very important. Next, we have joint tenancy. Okay. Joint tenancy. There are 3 people inside that circle. 3 people own the property. JT is different than a tick. If you guys see, is it divided? No. The shares are equal. So you got to remember, ticks, shares could be unequal. In JT's, the shares must be equal. So I'll read in a second. But when there's a question that says, John owes 1/3, Adam owns 2/3 of a property. What would be the best description of this form of ownership? The moment it says 1/3 and the other one 2/3, are those equal?
No.
The answer automatically is tenancy in common, ticks, automatically. There's no ifs or buts about it, don't move forward. If it's unequal shares, automatically tick. Okay? Yes? Okay. If it says John put $100,000, Adam put $30,000, and it doesn't say anything else about the deed, how are the shares divided? 50-50, automatically. Are we good? Okay. Next, it says 2 or more people can also choose. See, JTs, you have to choose to be a JT. A tick is automatic. When 2 or more people not married to each other acquire property, they become ticks automatically. Excuse me? They become ticks automatically. If not, they can choose to be JTs. Election. Okay? The main feature of a joint tenancy is that it carries with it the right of survivorship. What does that mean? It means that if C dies, it's just one less person in the group. So the shares do not go to the heirs. The shares are divided equally amongst the survivors. Okay? When A dies, everything goes to me, B. Okay? I'm usually the survivor in the groups, so don't partner up with me, just saying. So I would get everything here, 100%.
If there's not a deed.
I'm sorry?
If there's not a deed.
If there's not a deed, no. There is a deed, it's just we own it as joint tenants. If we own it as joint tenants, when you die, your shares come to me, not to your heirs. That's the feature of a JT. Okay?
I
Now-
want to go on that.
Huh? I would go on this one, absolutely. I'll explain in a second. Now, I showed you, the first one I showed you was something like this, right? There's a circle and only one person inside. So the end of a JT becomes a tenancy in severalty. It's one owner. The last one, the last owner can now do what? If I die, the shares go to heirs. So the last one, the survivor, is the only one that can give the shares to heirs. Why is this important? Because there's going to be a question. And that question says, John owns property with Adam as joint tenants. Before dying, John willed everything to his son Charles. Upon his death, who owns the property? And then there's 4 answers. That will say Adam and Charles, the son, right? It will say Adam by herself or and something else. So the correct answer is Adam. Because John died, whether he put in a will or not, it does not matter. They own as a JT. When you own as a JT, the will does not matter. The will written in the question is just to throw you off. You got it? They put extra stuff just to throw you off. It sucks, but that's what it is. Okay. Any questions here? No? Good so far? All right. So it says right here, joint tenants, please highlight, underline, put a star, cannot devise. Joint tenants cannot devise their property. That means they cannot put in a will. Okay. On the right-hand side on top, it says creating joint tenancies. Creating joint tenancies. To create a joint tenancy, there has to be 4 unities. Very important, 4 unities. Time, title, interest, and possession. Time, title, interest, and possession. 4 unities. I'll explain in a second. Time, title, interest, and possession.
Time.
The unity of time means that all joint tenants acquire the property at the same time, or their interests at the same time. So that means if all of us buy this building, we must be in the same deed at the same time, because unity of title says we're all in the same deed. Again, same time into the same deed, and then unity of interest says all joint tenants acquire equal ownership interest. Remember I showed you that there's no separation? We're all equal. And the last one is, next page, unity of possession. All joint tenants hold undivided possession of the property. So you don't have more than I do, we're all equal. 4 unities.
Can you,
Same time, same deed, same interest, same possession. Yes.
I see it's not clear for me for the creating joint or tenancy.
I'm sorry?
It's not clear for me like creating joint tenancy.
So the question is, TICs are automatic. So if it's, look at this, now, the two of us, we're unmarried, but we decide to buy property. Automatically, we're TICs. Tenants in common, automatically. We can choose to be joint tenants, but to be joint tenants, again, we have to buy at the same time and have the same interest, same title, same possession. Okay, so 4 unities must be present. In the TIC, I can, for instance, we're gonna add her right after. So it's the two of us, we bought property together, and then we're gonna add Heidi to the deed. She becomes a TIC with us. Does that make sense? In a joint tenancy, nobody can be added to the joint tenancy. They have to be added at the time that we're putting the names on the deed. Okay? Yes? So, right here, HW. It's going to be husband and wife, we're going to explain in a second, but going back to what you were saying, instead of putting ABC. So we bought the property together, let's say it's me and you, HW, right? We bought it together. But then we brought one more person. So,
As friend.
okay? We brought one more person. This person added later will have a separation of interest. See, me and you, we're still joint tenants. That third party that came after is a TIC with our joint tenancy. Okay? So for it to be joint tenancy, all the members must have acquired at the same time through the same title, same interest, undivided possession. 4 unities. We can add and remove people. But once we add and remove people, they'll never be joint tenants. What does this mean? It means that if C dies, the shares go to heirs. But if W dies, it's just one less person in the joint tenancy. Does this make sense?
Mhm.
Yes, no, maybe?
Yeah, it makes sense, it's just kind of odd.
Wait a minute.
So,
the person,
Okay.
the person that
if
came
the
out.
property is in, so the husband and wife have it as a joint tenancy?
No.
They're not married.
I just used, no. I just used, I had already written HW. Alright, hold on. A, B, C. There's 3 people that bought the property at the same time through the same interest, right? Same title, same possession. This is a JT. Okay? Then D came along. Separate interest altogether. D is now a TIC with our JT. Okay, so people could be added, they could be removed, but he separates the interest. When C dies, it's just one less person in the group.
Everything stays the same.
Everything stays the same in that portion of the ownership. If D dies, the shares go to heirs. Because they're in a TIC. And the TIC is a separation of interest. There is no right of survivorship in a TIC. The right of survivorship is only in the JT, which are the other members of the group.
Interesting.
Correct. Better?
You're not understanding.
All right, cool. Before we move forward, since I already addressed all this, thanks to your questions, which is okay, but since I already addressed, before we move forward, Why would you do a JT and not a tip? Anybody?
Maybe you don't have any heirs.
You have
If
more
I want
rights.
sole possession, maybe.
You have more rights.
Maybe you don't have no heirs.
You don't,
Maybe I don't have heirs.
It's less complicated when, I guess when somebody die, right? And it's not you, of course.
Ah.
You don't have to fight with the heirs.
We're getting somewhere. Here's what happens. JT is a business decision. So you're asking, you say you never do one of these, but it's a business decision, right? Dr. Gavin, we're in business, right? You're a businessman, I'm a businessman. We're gonna invest in real estate. But we're gonna do it as a JT. And there's a reason for this. See, I know he's a businessman, but I don't know his heirs. I don't know if your heirs understand anything about real estate or running a business. So it happens a lot, especially in TICs, that the heirs step up and all of a sudden, this is what we're gonna do. Like, wait a minute, do you even know what real estate is? Does that make sense? So by doing a JT was a business decision that if he dies, sorry, I have to kill you versus me, for example. Okay, cool. So if he dies, then I'll run the business because he trusts me to run the business. Now, this is ownership. That does not mean that his interest is lost. Because I can make an agreement that if one of us dies, we'll still take care of each other's family. That's a separate agreement. That's a separate agreement.
That could be
But the
odd.
deed, yeah, that's separate. That's partnership. That's operating agreements. That's a bunch of other stuff that we can create. But as far as the ownership itself, property now belongs to me.
You could send like a commission for the family.
I'll send a percentage. Which is
But
very common.
If you don't know about it, he don't do it, and he dies, you win.
Pretty much. That's why don't partner up with me because I'll survive. Sorry, Dr. Good.
So will you do it?
Do you understand? Business decision. I don't want nobody that doesn't understand this to come up and tell me how to run my business. Okay? We understood because that was our agreement. But anybody else? I have no idea. Imagine my kids coming and telling Dr. Kev, hey, we're going to sell.
How does your wife now, our wives now, play into this because now they have joint,
They don't.
not joint tenancy?
They don't. And here's exactly what happened to one of my
Somebody likes
clients. This is what happens to one of my clients. That's why I like it. So this is what happens to one of my clients. I was trying to help him not lose the home. And unfortunately, they still lost it because of a clerical mistake. And what was the clerical mistake? They did everything right. Just the attorney that was reviewing the paperwork did not pay attention to it. See, my client's wife, the deceased person, bought the property as joint tenants with her sister.
Oh.
Now, sisters were on the deed, husbands were on the mortgage with the sister. So there's two couples on mortgages, but there's only the sisters on the deed. So mortgage company goes like, the property is not yours. And we're like, what do you mean? Nobody paid attention. So then I started like going through the title, going through all the paperwork, and I'm like, how did this attorney not see it? Joint tenants.
She was smart.
The property.
Yeah, she's my girl.
Well, it sucks because all of them lost the property for not paying the mortgage. And there was nothing we could do because it was a last minute thing. We tried. But do you understand what I'm trying to say? There was a husband. Actually, there was two husbands. You got it? In a joint tenancy, we separate everything. Remember, after May 28, 1980, none of that married thing matters. You got it?
Protection too for you.
Yep. Got it? Yes, no?
Yes.
Go ahead, ask me.
He's not confused.
You got confused with what? Huh? I didn't hear what.
Yeah, you don't know about marriage.
Oh, because it goes.
You're gonna understand one day.
Let's not talk about marriage.
Ooh. Okay, marriage. No, what was your question? Where did you get lost? Okay, so, did everybody understand?
Yeah.
Okay,
It's a little bit confused, but.
it is confusing, that's why I slow down and I'll try to write as much as I can and draw it so you guys can see it, because this is a short chapter, but this thing alone, forget it. So, why would you do a JT versus a TIC? Business decision. What is the advantage of a JT? It's the right of survivorship. The main feature, you gotta know this because this is a question. The main feature is a right of survivorship, meaning one person dies, the other person keeps the assets. It does not go to heirs. Another thing to remember, TICs, unequal shares. It could be equal, but unequal shares is the most common. JTs, equal shares, period. You got it? Questions?
With the tick,
Yes.
you have to, it's automatic 50/50.
Yes.
Unless otherwise stated in the contract.
Yes.
Okay. Yeah, I got burned on that, long time ago.
Because you put more or less money.
The agreement with, I bought a, roughly at the time, we bought a condo together. She put the down payment, I took all the appliances, the window treatments, everything, took care of everything, interior. I went away to medical school, she sold the condo, so my name's on the deed, her name's on the deed, so I'm taking 50/50.
Mhm.
Getting two attorneys involved, and my attorney says, no, she put my money down, did you have no proof that you put money down? She's still living in the property, you went away to medical school, she gets more shares.
Wow.
So on the deed, it did not say 50/50.
Yeah, well, it's both our names, it didn't say anything.
But that's what I'm saying, it didn't say anything about separation.
Proportionate
That's what he
shares.
said before, if it doesn't state specifically if it's 30 or 50 or whatsoever.
It should be 50/50. If
Yeah.
it does not specify.
Hired two attorneys, and my attorney says no. So that's what I'm saying.
And this was in
Attorneys-
Jersey?
Yep, attorneys are always not what you think they are.
No, I know.
Yeah.
I know very well.
The-
I just told you, one of my clients lost the property because of that joint tenant thing.
So basically, you cannot rely on an attorney, you have to go to the paperwork yourself.
Due diligence.
Just make sure
Well-
you read.
Yes and no, yes and no. So
No, I have,
attorneys are supposed to be there for you, but unfortunately, just like realtors are supposed to be there for you, but some are lazy, some don't care, and some are really good at what they do. So 20% of the attorneys are really good at what they do.
20%, that's it?
Yeah, nationwide.
Oh my
Where
God.
do you say-
I think that's what everything,
I said attorneys, not me. That's what happened to average
that's what everything,
with everything, right?
it's an 80-20 rule.
That's right. All right, tenancy by the entirety. Guys, just do me a favor, try to avoid your phones for a second, please. We're almost done. If you're on your phones, you're not learning. If you're texting somebody else, then you're not paying attention to the class. And you know what? I always say this in my classes. I already got my license, and I'm happy to get paid by you. Got it?
So the second,
Yes.
third.
Hey,
Whoa, wait, I'm scared. You were your second time, third time. I know your reason.
where's your
You mean
phone?
you're not learning?
Where's your phone?
It's in my bag.
Great.
No,
Next.
Just get paid and didn't attend.
So here's the thing, tenancy by the entirety. A tenancy by the entirety is a special tenancy between husband and wife. Before I read, if you guys look at it, what does that look like from the previous examples? Severalty, TIC, or JT? JT. So between the husband and wife is very similar. So one of the things that you gotta know is that the owners must be husband and wife when they receive the property. They must be husband and wife when they receive the property, okay? The owners have right of survivorship. What does that mean? It means that if the wife dies, the husband gets everything. They must have purchased the property together. Remember this. Both names are there. If the wife dies, husband gets everything.
You're just killing the woman, no reason.
I'm sorry. What was your question?
I'm just kidding.
So does this also apply to same-sex marriages?
Yeah, so spouse and spouse, let's put it like that.
Okay.
Yeah.
Spouse and
Spouse and spouse.
spouse. Okay.
The book mentions husband and wife, but yes, spouse and spouse. Okay? Now, let me ask you something. What if there's a divorce?
50-50?
Wait. There's a divorce. And now, special request, sorry guys. husband dies. What happens to the shares?
It's hers.
Hers.
No.
Why?
It takes the same.
Why is it hers?
Oh wait, is it divorced and the wife already left?
She's the ex.
Oh,
Oh, it's there, so it goes to the heirs.
I said divorce,
let's do it.
So it goes to there.
so it goes to his heirs. Okay? She's only entitled, right? So the spouse is only entitled to the shares while they're married. As soon as they divorce, like you asked before about divorce, I said the divorce decree will determine if they abandon claims or not. But we could still own this property even after divorce, right? We still own it together. The difference now is if I die, the shares go to my heirs, they don't go to the spouse. You got it?
And this only happen in husband and wife?
Tenancy by the entirety is specific for husband and wife.
And then it'd be the same if it was the opposite, right?
Yeah, so,
Specific, right?
yeah, spouse and spouse, so equally, husband and wife equally. Once the wife dies, the shares will go to heirs. If the husband dies, the shares will go to heirs.
Heirs meaning
If they're
like the kids and
divorced.
stuff, right?
Heirs is whoever you determine. I can have a will that says the heirs is the cafe next door.
But I know, but in this case, let's say that in his deed specifically says that it will go part to his wife, can that happen? If
The-
it's on a deed?
If he died before changing the deed, saying that.
If I want to have name my ex-wife in my deed, my will, I can. The will determines who gets it.
Yeah, yeah.
So in this case, there's a divorce. There's a divorce. I don't think my ex-wife is getting anything.
I mean, you even forgot about the deed.
Does that make sense? No, I'm saying in general.
Oh, I
But
thought
it
she
could be,
died.
I could be conscious, hey, it is the mother of my children, so let me give something. Whatever I want. It's all determined based on the will and divorce decree. So remember that. In New Jersey, this is something else that happens automatic. In New Jersey, a conveyance to a man and a woman, please underline, who are legally married to each other, creates a tenancy by the entirety. If it's husband and wife, it's automatic tenancy by the entirety. Unless the deed expressly states otherwise. What does that mean? Unless they decided to be ticks. Got it? Yes?
Yes.
So, if there's, let's sum everything up. If there's one owner, it's automatically tenancy and severalty. If there's two or more people not married to each other, it's automatically tenancy in common. If there's a husband and wife, automatically tenancy by the entirety. These three are automatic. The only one you can choose is joint tenancy. Questions? No? Awesome.
I have a question.
Yes.
So what if you are, okay, for example, myself. I might have to ask this question after we're confusing people.
Go
But
ahead.
I am still legally married to my husband.
Mhm.
However, we have been in separate households for almost 8 years. If
Okay.
he buys a house and I'm still legally married to him, I am still responsible. I still have to deal with all of that, which he does
If you're still married, yeah.
legally, right? So there's no law in New Jersey that says if you're separated from the household for X amount of years, then you're not held with that?
Was the your name is on the deeds? Sorry, I forgot to ask that.
No,
Okay,
no.
that's
no.
different.
Okay,
What is your name on the mortgage?
no, not as far as I'm aware.
That's different. Can they still sue you or attempt to sue you? Yes.
They can.
After a while of showing the, see, lawsuits, okay. I love America for one reason, and one reason only. You can sue because you look at me wrong. You can sue because of a hot fry, because a coffee spilled while I was driving drinking hot coffee. You can sue because fast food makes you fat. But you cannot sue because two labels are competing with each other publicly. It's the funniest thing. Pepsi is better than Coca-Cola, like literally put it out there. All other countries, you cannot do that. You cannot be direct like that. But then everything else you can sue. You got it? So can they come after you? The answer is yes. Will they win? If you can prove they have no dealings with it for X amount of years, then most likely you won't have a problem with that. But don't quote me on that. An attorney would be best to talk about it. Does that make sense? Okay. Next, we have business forms of ownership. So we got LLCs. Oh, I'm sorry. Actually, I skipped something. Sorry. Partnerships. There's a reason I skipped partnerships. Sorry. Sole proprietor is just you owning with tax ID by yourself. So partnerships. There's two different types of partnerships. Yes, big no. No. And oh, there you go. All right, partnerships. There's general partnership and there's limited partnership. A general partnership, you guys can highlight as I speak. A general partnership is all of us decide to purchase this building together and we do it in the form of partnership. But we did not define who's the manager, who's not. So all of us are general. What does that mean? We all have a saying or voice in the operations, daily operations of the business. So, if we make $1 million, all of us share the $1 million, and we all happy, right? Yes?
Yes.
If we get sued for $1 million, all of us share the liability of the $1 million. Is that good or bad? It's good if we all share, correct?
Yeah.
Here's the difference. Only one of us can afford to pay the $1 million, as an example. Guess what? That person, because of shared liability, that person has to pay the $1 million and then collect from everybody else whenever possible.
Wow.
General partnership. Everybody's liable.
That's what you
Sure,
were
like-
saying, no, too, or the sole proprietor.
I'm saying no to sole proprietor. I'm saying no to general partnership. Corporation depends. LLC definitely. We're getting there. But general partnership, no good. Okay?
LLC definitely no.
No, LLC definitely yes.
Okay, good.
Sorry. I said no to everything else.
Okay.
Now we have limited partnership. It's getting a little bit better. Limited partnership, every time you see limited, it gets a little bit better because there's a limitation on lawsuits, the exposure. So as you guys highlight, whatever is green, put stars. In a limited partnership, there must be at least one general partner, at least one. Everybody else could be limited. So the example is, guys, I want to buy this building. You guys got the money, I got the know-how. So I'm going to be the general partner. I'll command the whole thing. I'll manage the whole thing. You guys put up the money. But you will be limited partners, meaning you have no say in what I do. You just put the money. Does that make sense? So you guys are now investors. Here's the thing. If we make $1 million out of the sale of this building, we all share the money according to our fractional interest. Okay, we all share. That's great, isn't it? We all make money? Yes. Here's the biggest difference between general partnership and limited partnership. If we get sued for $1 million, let's say each one of you put $10,000 into the business. If we get sued for $1 million, what do you guys stand to lose?
All your investment,
Only your investment. Okay? And guess who has to deal with $1 million? The general partner. You got it? So limited liability or limited partnership in this case is I asked you to participate, but I took the full responsibility and liability in the business. Good? You got it? Awesome. Corporations. Corporation is an artificial person or legal entity created under the laws of the state from which it receives its charter. Because a corporation is a legal entity, real estate ownership by a corporation is in severalty. Or, as tenants in common, if it is a partial ownership. Because of its possible perpetual existence, a corporation cannot hold real estate as joint tenant. Real quick, what's the main feature of a joint tenancy?
The one die or leave.
The right of survivorship. Yes. So if one dies, it goes to the others. Right? So what we're saying here is, a corporation cannot own property as joint tenants because a corporation might not die. Does that make sense? So if a corporation could live forever, let's say I buy as an individual and you own with me as joint tenants, who's going to survive? The corporation. I'll die for sure. That's why we can only own in severalty if it's one corporation owning everything, or as tenants in common, because it could be corporation A and corporation B partnering up to own the building.
Yeah.
Okay? You got confused there for a second.
Mhm.
Go ahead, what's your question?
Okay, corporation is, let's start from the beginning.
Corporation is, you're gonna prepare a legal protection. That's what it is. It's a document that says you incorporated. You now have Melanie Investments Inc., for instance. Okay, so it's no longer you, it's your company that owns the building. That's a corporation. Good? But you could own, so Melanie Investments Inc. with Tasia Investments Inc., for instance. And both of you buy the building. Now you're TICs. Tenants in common, separated shares. Good? Okay. Skip a paragraph. It says, a corporation is managed and operated by a board of directors. These are the people that make decisions for all the shareholders. Individuals participate or invest in the corporation by purchasing stock. And because, please highlight, put stars, because stock is personal property, shareholders do not have direct ownership interest in real estate. So, if we have Newark Investments Corp. that owns the building, and we're all investors in Newark Investment Corp., what do we own?
The corporation. Just the stocks.
We just own stock. Who owns the building?
The corporation.
The corporation. So a corporation is a separation between you and the entity that owns. Why do we want this separation? To limit liability. Because if somebody's going to get sued here, is the corporation. So a corporation becomes a shield, a legal protection. They cannot sue you as an individual. Does that make sense? Okay.
I have a question.
Yes.
What are directors the owners?
Is whoever is elected to be the board of directors. So usually it starts with the owners, and then as they sell shares, some of them could have voting shares. So it splits into different types of shares. So voting shares means that you can vote me out. If there's enough of you that say, hey, Bruno shouldn't be the CEO, okay? So you can vote me out of the board if you want. Does that make sense?
Yeah.
But some shares are non-voting shares. So it doesn't matter what you do, you can never kick me out. Okay? On top we have LLCs. You see it? Do you see LLCs?
Yes.
Yes. This is my favorite, yes. They're the easiest to form, easiest to maintain, great protection if you're not going like multi-investors and multi-employees and all that stuff. If it's just you, and maybe a handful of people, you buy the building under an LLC. Okay? So what is an LLC? An LLC is like a hybrid between the partnership and the corp. It's still a shield, it's still protection. Okay? But again, LLC members have the tax advantages offered by partnerships and the same limited liability offered by the corporate form of ownership. So you have the protection and tax benefits. Okay? Way better. Next, you're looking up that information on the phone?
What, you know, everyone's.
Other forms of ownership. That's at 10. You got time? Other forms of ownership. They're syndicates. Syndicate is a joining together of two or more people to carry out a particular business project. Then we have joint ventures. Is an organization of people or firms designed to carry out a single project. The difference, or the biggest difference between these, is that a joint venture, please highlight, underline, put stars. lasts for a limited period of time, and does not establish a continuing relationship. So joint venture, short period of time, not intended for long term. That will be possibly the answer in the exam. We also have REITs, but we talk about that in chapter 17. We're almost done, guys. Final run. It says growth of condos and cooperatives or co-ops. It says condo and co-op ownership of housing has risen in the second half of the 20th century, together with townhouses and planned unit developments. Condos and co-ops offer the emotional, financial, and tax advantages of home ownership combined with various advantages of apartment living. So it's like being a tenant, but you own something. Okay, so tenant, you don't have to deal with all the headaches of snow, right? Maintenance, garbage, right? But you own something. So skip a paragraph. It says, contributing to the growth of condos and co-ops are the changes in population patterns, with increasing numbers of single homeowners, one-parent families, and senior citizens. So such groups, community living offers security and sociability, ease of maintenance, and sometimes the opportunity for sharing expensive recreational facilities like swimming pools and exercise rooms. So if you're advertising to a group for condos, the group would be, again, single homeowners, one-parent families, and senior citizens. Remember we talked about this yesterday? I said if you want to advertise, if that's going to be your niche, your focus, people that are becoming senior citizens, they want to most likely downsize and not have to deal with snow or trash or maintenance. So you advertise to those groups in order to get them into condos or co-ops, okay? Next page, so we figure out the difference between condos and co-ops. So condo ownership. Condo ownership, the difference between these. In a condo, buyers of a condo receive a deed. These are like cell phones, so I have to keep repeating. Deed. When you buy a condo, you receive a deed. That means you're a owner of the property, conveying fee simple ownership to two things: their living unit, from the paint on the interior walls inwards, and a proportionate, undivided interest in common elements. So here's what we're saying. In a condo, you own from the paint in. From the paint out, doesn't belong to you. You got it? So if you chip that paint, you already lost property. Just saying.
How dare you?
Right?
Be careful with those walls.
So you can't put nothing on the wall?
Pardon?
You can't put nothing on the wall?
Interior.
The interior, yes. What we're saying is,
Can't cut through.
can cut through. Yeah. Okay. Next, in many respects, next paragraph, a condominium owner may be regarded with the same light as an owner of a single detached house. Title may be held in severalty by the entirety as joint tenants or as tenants in common. Same thing that we just went over, right? Now the unit receives an individual tax bill. Okay? And baby mortgage, individual mortgage, as a house would be. The owners also place a separate insurance. A separate insurance policy on their living space. Okay? Income tax advantages are identical to those for single-family homes, and the owners are free to sell the property and lease. Give it away or leave it to the heirs. You can do whatever you want. One of the differences between this one and the other one is the lease. That's why I wrote this here. Each unit is its own financial entity. Please highlight, underline, put stars, bubbles, arrows, whatever you gotta put. And if an adjoining unit is foreclosed, no obligation is incurred by the other owners. I'll explain that in a second. Owners are, however, bound by the bylaws of a homeowners association, to which all belong. HOA, to which all belong. On the right-hand side on top, as long as the rules are not unreasonable. New Jersey law permits association to enforce their rules by fining residents who fail to comply. And of course, there are fees, HOA fees involved here to maintain for common elements, right? If unpaid, I have this in green because it's important. If unpaid, these common charges become a lien against the individual unit and may even be enforced by foreclosure. So if you don't pay your HOA fees, the homeowner association could take you to court and take over your property, foreclose on your property. So you lose because of a $200 bill. Okay? Now the bylaws also set up covenants, conditions, and restrictions, CC&Rs, which is, for example, they may prohibit a display of a for sale sign. You want to sell your property and you cannot put a for sale sign. Isn't that crazy? Also, they might say that you cannot paint your front door bright red. Who wouldn't want a bright red door?
Does anyone actually?
How about neon green? That would be my preferred. It's neon green. What do you think? I don't have to give you the number of my house. Just search for the neon green one.
I heard a story, some guy bought a brand new pickup truck, F-150, lived in a community, and they told him he can't have it as a commercial truck.
Covenants, conditions, and restrictions. All right. I want you guys to go to the next page and then we're going to come back, okay? Come back to that part. For now, I want you to go to co-op and I'll come right back. Cooperative ownership. Cooperative ownership, which is common in New York City, is also found in certain areas of New Jersey. Under the usual co-op arrangement, title to the land and the building is held by a corporation. It is owned by the corporation. Each purchaser of an apartment in the building receives stock. So, stock and a lease. So you receive stock and the lease. I'm sorry, I gotta change the, but what it says there is stock and lease. So you as an individual owner receive stock and the lease, proprietary lease, which gives the purchaser the right to occupy his or her apartment. So wait, what do you own in the co-op? Stock, and what else? Nothing else. So in a co-op, you are a glorified tenant. What does that mean? You are a tenant shareholder. You're somebody that lives there or has the rights to live there and owns a part of the building through the corporation. Does that make sense? So you're not the owner of your unit. You're owner of the rights to your unit and stock in the corporation. Okay, so you're a tenant shareholder. So you got to remember, co-ops, you're tenants. You are tenants. The cooperative's building real estate taxes are assessed against the corporation as the owner, and there's usually one underlying mortgage for the entire parcel. So that means that the corporation has the tax, mortgage, I'm sorry for my handwriting, and insurance. So it's not the individual, it's the corporation that has this whole thing against the building. So it's one against the building. You guys got it, building. Okay? So the corporation has one tax, one mortgage, one insurance against the building. Okay? And what they do, it says right here, they divide that expense amongst the tenant shareholders in the form of monthly maintenance charges. Monthly maintenance charges. Okay? So what do you own? Stock. Period.
Use, you only like allowed to use the certain area.
It's a lease. You're the tenant. So it's like you're living in an apartment building. You can use your unit and whatever common areas that they allowed you to use according to the lease. That's all it is.
The good thing is that with this, you own stocks.
That's the difference.
Yeah,
You're not just a tenant.
you're not just a tenant that goes and buys,
Correct.
you have certain
I
ownership.
don't really understand that. So they work for this company or something and they're giving them a house or an apartment?
No. You buy into the ownership of a building.
It's like you have stock.
So let's say all of us want to buy a building. Do we have to occupy the building? No. So together we buy the building. So we're the owners. We have the right to a unit in the building. We have the right to it. Does that make sense? Simple. We're owners of the corporation through stock, and we have a unit, a proprietary lease that allows us to use a particular unit. Simple as that. Do you want to buy the right to more units? You buy more stock. Yes.
So, because I just came from a situation like that. I just came from a co-op. And the board of directors, the president of the board of directors is acting as the landlord.
So the board of directors is the landlord.
So
They
they're-
represent the corporation.
So they're allowed to inspect other shareholders' apartments? and
Yep, because you're a tenant.
stuff? Okay. And how does the tenant shareholder get their investment back or their stock back when they move out?
You can sell.
These shareholders don't know that.
Well, you bought shares, you
They
can
don't
sell
even know
shares.
that they have they don't understand it as that.
Possibly, but you bought shares, you can sell shares.
So does it act as a security deposit for their,
No,
no?
security
So
deposit,
I'm a
no.
shareholder. I
You
wanna
leave,
move
if
out.
you don't sell your shares, then
Yeah.
you don't get anything. There's no security deposit. You have shares in a corporation. As long as it increases its value, you're gaining money. If it loses value, you're losing money.
And they need to be informed of how much they have in the share, right?
Yep. What the value is, but that's why the board of directors they have their own bylaws where it says how often they reevaluate the value of the property in the corporation. Yep. But when you buy into it, you should know what it is.
I
It should
mean,
be.
it's not specified.
Well, what I'm saying is you should, meaning it should have been described to you what you're getting yourself into.
Yeah.
Because to get into a co-op, it's not like a month and a half you're in. It's a $50,000, $60,000, $70,000, $80,000 investment, as an example.
Well, then I don't know what they're doing over there.
Okay.
And so,
I want to talk to you, separate from the
It
class.
doesn't sound like a co-op.
That's why I'm going to talk to you separate from the
Okay.
class.
No problem. All right. So what else we have? It says right here that co-op bylaws generally provide that each prospective owner must be approved by the board of directors. Why do you have to be approved to come in? Because you're a tenant. So I need your score to be 7+, right? I need you to make $100,000 a year or more. I'm qualifying you as a tenant because that's what you are, tenant. If you don't meet our qualifications, then you cannot buy into the co-op. Does that make sense? So one disadvantage of co-op ownership is the possibility that if enough owner-occupants become financially enabled to make their prompt payment of their monthly assessments, the corporation might be forced to allow mortgage and tax payments to go unpaid. So through such defaults, the entire property could be ordered sold by a court order in a foreclosure suit. So such a sale might destroy the interest of all owners, even those who paid their assessments. So here's what I want to say with this. In condos, the first one, each unit is its own financial entity. What does that mean? It means that if you stop paying your mortgage here, your unit gets foreclosed, but it does not affect the ownership of the other units. In a co-op, if enough people in the building stop paying, the whole building gets sold in a foreclosure. So those that were on time lose. Did you guys get that? Okay. All right. On the right-hand side on top. Okay, you see here that I put lease in condos? On the right-hand side on top, it says, many co-ops do not permit rentals. They do not permit rentals. That means when you buy into the co-op, you cannot have somebody else live there. It has to be you. Because remember, you are a tenant. If you bring somebody else, that's called subleasing. You got it? Most leasing agreements do not allow subleasing. In this case, that's what it is. Enjoy your weekend. All right? That's what it is. However, even though they say no, a recent New Jersey law provides that owners of co-ops in buildings with 10 or more units may rent their units. So they allow you to lease your unit if, please highlight, underline, put stars, if they have been trying to sell for 4 or more months at a price no greater than their investment. So let's say you bought into this co-op for $100,000. And now things got tough and you want out. You want to rent to somebody else to make it up, maybe. The only way they allow you to rent is if you put your property on the market at a price no greater than $100,000, at least recover your investment. If at that price you're still not able to sell, then you got to go to the landlord, board of directors, and ask, please, can I rent my unit? Does that make sense?
And if they say no?
Well, the law, this recent New Jersey law, allows people to do this. So the board of directors has to follow this rule.
So we still need the permission.
You still need to go to them and say, hey, I've done this. I've done all the steps according to the law. Please allow me to rent now. Okay? Next, it says the corporation's right, all the way at the bottom, the corporation's right to accept or reject any new owner is aimed at safeguarding present owners. So what we're saying here is, the reason why I have to approve you or your income and all that stuff is because I want to make sure you're not going to default. Because like I said before, if enough of you default, all of us lose. So I want to make sure you're sound and stable in your financial and economic situation, right? That you got reserves, that you have like 6 months in the bank that I can see you can pay for this. You have a good job, a good steady job, so on. Now, do me a favor. Let's go back to where it says establishing a condominium. Establishing condominium. Okay. Where it says establishing a condominium, I want you to highlight in New Jersey, the creation of condos is regulated by the state's Horizontal Properties Act and the Condominium Act. In New Jersey, for you to create a condo, it's regulated by the state's Horizontal Properties Act and the Condo Act. And that's all you need to know here.
All right.
Huh? Easy.
All right.
Easy, right? Next page, where it says condo conversion. This you need to know. Condo conversion. The landlord who desires to convert rental apartment building into a condominium must obtain approval. Look that I have this underlined. You must obtain approval of the planned conversion by the state of New Jersey at least 3 years and 2 months before the conversion may start. At least 3 years and 2 months before the conversion may start. So, you're tired of being a landlord. But you know if you sell the building, you're not going to get the most for your money, right? So you want to convert it and sell each unit individually. You got to wait 3 years and 2 months.
Like a house in rooms? Like you have an apartment?
No, let's say this is an apartment building right here. And these are all my tenants. I'm just tired of being a landlord. So I'm going to convert each unit to be independent. And I'm going to sell each unit independently. Condominiums. Now, houses in a row, if they're in a private gated community, they're condos. Okay? Or they could be condos. Now, for us to convert to condos and sell the units, we need to kick out the tenants, right? Yes? But here's the thing. Certain tenants are protected. So tenants with disabilities and those aged 62 or older may not be evicted during the condominium conversion. The tenants so protected must have occupied the premises for at least 2 years before the conversion and have incomes no higher than three times their county's per capita income, or in any case, no more than $50,000. Okay, so if they make more than $50,000, they don't qualify for this. If they make less, then they are protected. If they meet these qualifications, then they're allowed to stay for up to 40 years. You cannot kick senior citizens or people with disabilities out of that rental. They're allowed to stay up to 40 years because their income is limited. Once they move, where are they going to go? So it becomes difficult, and that's what they're trying to protect. Go to the right-hand side. At the bottom it says townhouses. The only thing you need to know right here is that a townhouse is used to describe an architectural structure style in which buildings share a party wall. They're houses in a row. These are townhouses. Houses in a row. They share a party wall. That's it. That's what you need to know. And then we have time scamming. Scamming. All right.
You were correct.
I was correct, right? I know that's what I saw. So the buyer of a timeshare receives a fraction of a year's ownership or use of a property. So you don't get full ownership, you don't get to occupy the whole year, you get a fraction of it, which might be a hotel, townhouse, single-family detached home, campground, or even a motel. Now, in some cases, only the right to use is purchased. In others, the owner has true fee simple interest in real estate. What is fee simple? What is fee simple ownership? We have fee simple, we have fee determinable, and life estates. What was fee simple? Nope, that's in several too. Fee simple, it's simple. You're the owner and nobody can take it away from you.
That's what I'm saying, it's just you one.
Well, it could be 2, it could be 3, it could be 10. But you can pass it along to your heirs. Got it? You guys don't remember that?
No, I mean, you can consider it 1, 2, 10, if it's just you, it's just you.
So, if we own in fee simple, there's no condition. See, fee determinable, it's yours as long as.
Okay.
Life estate is yours as long as somebody's alive.
Right.
But fee simple is yours.
Okay.
All of us could own fee simple.
Until the term age of 5.
Okay?
Fee simple, no conditions. Yeah.
No conditions. So you can have the right to use, so an interest or a claim, right? Or fee simple, meaning it's yours. It's a portion that's yours. At the bottom it says, an owner can exchange, sell, or rent the time slot, subject only, please underline, subject only to any restrictions. Subject only to any restrictions in the prospectus of the organization administering the property. So, it's yours. You can do whatever you want as long as you don't go against the guidelines that they provide to you after the sale, not before the sale. Okay? And that's pretty much it. You guys good? All right. You have a good weekend.
Why you always say everything though?